President Biden, on January 17th, while he was still in office, announced that the Equal Rights Amendment was now law of the land. The Equal Rights Amendment was proposed by Congress in 1972 and sent to the states for ratification with a 7-year limit. If the required 38 states didn't ratify in that time, the amendment would be considered void. In 1982, Congress extended that time limit, and since then, the amendment has been passed in the required 38 legislatures. So the question I think most of us would have is, okay, so they submitted an amendment and they put a time limit on it, and then the time came and it hadn't happened, so they extended the time limit, and now they've gotten it. So what's the issue? Why isn't it officially an amendment, right? So Michael Farris, who is, if you are not aware, one of the founders of Convention of States and a constitutional law expert. He has argued in front of the Supreme Court numerous times, and he's argued Article 5, I believe, in front of the Supreme Court as well. So he's very well versed in all of this law stuff that the rest of us aren't necessarily as versed in. He said the state of Idaho and legislatures from Idaho, Arizona, and Washington challenged the constitutionality of Congress making that extension on the time limit. And I'm paraphrasing here, he said the acts of Congress. And I'll continue the quote. He says, I personally represented the Michigan legislatures in the state of Idaho versus Freeman, 529F sup 11. I'm going to just skip the numbers, people. I will continue the quote. The court ruled the ERA, the Equal Rights Amendment extension, to be unconstitutional. The basic holding was that Congress lacked the power to change the rules in the middle of the stream. The Supreme Court of the United States noted probable jurisdiction, but held further consideration until the second deadline passed. It then ruled that the case was moot because the ERA was dead under any theory. Now, another point that he makes, this is actually a very long, if you're interested, and you go to Facebook, you can find Michael Farris and read the entire thing. It's very, very interesting. He also points out that when they extended the deadline, they did it with a simple majority. They did not extend this deadline using the 2/3 required vote in both chambers that is constitutionally required in Article 5. So if you consider that, the extension of the deadline would have, from my simple reading, been illegal under the Constitution itself. So very interesting stuff here. I know that the proponents of the ERA are pushing for this to go to the Supreme Court again, but that's kind of the interesting dilemma of this case. There's a few interesting things here. One is I think it's important to point out how specific Article 5 is and what has to be done to get an amendment. There are all of these very important points that have to be followed, which of course we're somewhat aware of, I would say, in Convention of States, since that's kind of what we do. But this is Congress trying to do it. And I think people need to understand, even when Congress proposes an amendment, there are all these checks and balances because, you know, here they went, they tried to do it, they tried to extend it, but there's all these legalese. It's just not even that simple, even when Congress tries to do it. So there really are a lot of checks and balances to the process. The second issue here is the fact that President Biden tried to make this law of the land with a statement as a president. These are kind of two interesting warring things. One is the very specific legalese that go into this, and the second is should a president have the power to essentially override the system and say, I declare this as a law because it had 38 states ratify it. What do you think on that?
Shay, I'll let you go first.
Oh, great. Yeah. So, I mean, all these points can be argued. And, you know, unfortunately, I'm not on the Supreme Court, so I don't get to make a decision about any of this stuff. I mean, I hear all these components, not the least of which, by the way, which we haven't talked about, and that is, how is it going to be applied? I mean, the initial intent was really straightforward, I think. You know, you want to make sure that women have equal rights to everything that men have and so forth and so on. And hard to fight that. That seems like a pretty straightforward undertaking. But then how is it going to be implemented, and what are the ramifications of that? And, you know, you start talking about this gender issue, and then you start talking about sexual preferences and all that. And all of a sudden, is that also included by definition into this? So, what started off as simple language back in 72 is not so simple anymore. And so it gets to the point of it opens up different avenues than we really were thinking about when we think about this ERA. And I guarantee you the states that ratified this early on didn't understand what was how the language is going to be reinterpreted in 2025.
It's an interesting point. I haven't looked into it thoroughly enough, but I did hear that some of the states that ratified it then went and withdrew their ratification.
Yeah, they did. Five states did.
Which is another interesting point of, okay, can you withdraw ratification?
I don't think you can.
It's which we actually encounter with Article 5, because there are states that pass Article 5s calling for a convention, and then afterwards, many years down the line, go through and say, actually, we want to withdraw that request. Right. And that, I don't think that's ever gone to a court either on whether or not you can legally do it. For anyone who's watching and is wondering, none of the 19 states that have passed the Convention of States resolution have done that. All 19 states are 100% legally on board.
Right.
There is no question about that. But it does beg questions here with the process that it's just uncharted territory. Not how the process works, but these interesting little questions that people.
Right, exactly. I would argue, if you put this out to the 38 states today, even if they all agree, do they all agree with the language that's there now? Because and I know that the interpretation of the language is going to be different than what it was in 72. Mm-hmm. So you can argue yes or no and so forth, but really to me that's the gist is what are really arguing for with ERA? What do we want to do and what do we want to accomplish? And is everybody saying the same things?
Mm-hmm.
To me, this shows what a quagmire it is to get legislation passed. Mm-hmm. And all the people that get involved and touch things. We've seen some things that Trump has announced this week, and it's already headed for the Supreme Court. And, this happened back in, you said 72.
Mm-hmm.
I until this all came out, I wasn't aware of all the jockeying around that has gone on about it. And when we talk to people about holding a convention of states and our platform that we have, they're afraid that something like this might happen. Okay. And we've set things, there are rules in place for that I think will affect us, but the rules are also there, as we'll see. Now it will have to be tested by the Supreme Court. And ultimately, I want to read a response from Michelle Conley. She's an emphatic no. The president should not be able to override Congress. That would wash out separation of powers. Congress writes laws, executive branch executes.
Absolutely. That's the way I read the Constitution. I think that's the way we all read the Constitution. So, yeah, it's very interesting times we live in.